So, let's dive into the world of biometric data. We're talking about your fingerprints, your face scans, your voice prints, all the things that make you uniquely you. We're going to look at one single, pretty groundbreaking law from Illinois that has kicked off a total tidal wave of massive, high-stakes lawsuits. And this whole story, it really starts with one company and a number that is just, well, it's mind-boggling.
Take a good look at this number, $17 billion. Now, that's not a company's market cap or its annual revenue. Nope, that's the potential liability that one single company, the fast food chain White Castle, was staring down the barrel of, just for scanning its employees' fingerprints so they could clock in and out.
So that's the big question, right? How on earth does scanning a fingerprint turn into a multi-billion-dollar problem? Well, that's the very heart of this explainer. And to find the answer, we've got to rewind the clock all the way back to 2008 and take a look at a law that honestly sat on the books pretty quietly for almost a decade before completely exploding onto the legal scene.
And it all starts right here, with BIPA. That stands for the Illinois Biometric Information Privacy Act. It was passed way back in 2008, and it was literally the first law of its kind in the entire country. Its whole purpose was to regulate how private companies could collect, use, and store our most unique, most unchangeable data.
This right here, this quote, gets to the very core of why this law was created. You know, the lawmakers in Illinois realized that our biometric data is just different. It's not like a password. If your password gets stolen, you just change it, right? Problem solved. But you can't get a new face. You can't just order up a new set of fingerprints. Once that data is compromised, that's it. The risk is permanent. And that's why they felt it needed this special, super protective legal framework.
So, what exactly does BIPA protect? Well, it breaks it down into two categories. The first one is biometric identifiers. Think of these as the raw biological data itself. The scan of your retina, the unique ridges of your fingerprint, the patterns in your voice, or the specific geometry of your face or hand. It's the source code of you.
Okay, so you have the identifier, but then there's this second, much broader category called biometric information. This is the digital stuff that gets created from your identifiers. It's the digital template, the mathematical code, the hash that a computer system generates from your fingerprint scan. If that digital file can be used to identify you, guess what? It's protected under BIPA.
To protect all this data, HIPAA basically laid down these 5 golden rules for any private company. First, you've got to have a public policy explaining how long you'll keep the data and when you'll get rid of it. Second, and this one is the absolute key, you must get informed, written consent before you even think about collecting the data. Third, no selling it. Fourth, no sharing it without permission. And fifth, you have to protect it with a reasonable level of security. Seems pretty straightforward, right?
Well, for about its first 10 years, BIPA was, a sleeping giant. Nobody was really suing under it. It was just there. But then a series of court decisions came along and completely changed the game, giving this law a serious set of teeth and unleashing thousands of class action lawsuits. It all came to a head with this kind of 1-2-3 punch from the Illinois Supreme Court. First, in 2019, a case involving Six Flags established that you don't even need to prove you were actually harmed to file a lawsuit. A simple technical violation was enough. Then, in 2022, they ruled that employees could sue their employers directly. And finally, in 2023, 2 huge rulings came down that created a 5-year window to sue and, this is the big one, said that every single scan could be a brand new violation.
That 2019 Times-Rosenbach decision, that was the spark that really lit the fuse. By saying that a simple mistake, like just forgetting to get that written consent form signed, was enough to get sued, the court basically opened the floodgates. And did they ever open? Over 1,500 BIPA class action lawsuits were filed in the years that followed.
But if Rosenbach lit the fuse, the Cawthron vs. White Castle case was the bombshell. This is where those crazy numbers come from. The court decided that every single time an employee scanned their fingerprint to clock in, to clock out, to access a computer, it counted as a separate, brand new violation. And each of those violations came with a penalty of $1,000 to $5,000. All of a sudden, the potential damages just exploded into the stratosphere.
And believe me, this wasn't just some theoretical legal threat. The financial consequences were very, very real. Just look at the tech giants. Facebook, now Meta, paid a staggering $650 million to settle claims over its photo tagging feature. TikTok was hit for $92 million, and Google for a cool $100 million over its photo tool. We're talking serious money.
And it wasn't just about big settlements with tech companies either. This number, $228 million, was the actual verdict in the very first BIPA case that went all the way to a jury. A group of truck drivers sued BNSF Railway because they had to use a fingerprint scanner to get into the company's rail yards. The jury found the company had recklessly violated the law 45,600 times, and they hit them with the maximum penalty for every single one.
So, this threat of what the White Castle Court itself called annihilative liability, damages so enormous they could literally bankrupt a business, finally got the attention of the Illinois legislature. They looked at the situation and realized the per-scan ruling had created a monster they had never intended. So, they decided to step in.
And what they did was pass a really critical amendment in August of 2024. The new rule is simple. Repeated scans of the same person using the same technology now count as only a single violation when you're calculating damages. This basically slammed the brakes on that runaway liability threat from the Cathron case. So now, an employee clocking in twice a day for 5 years isn't thousands of violations, it's just one.
But of course, that created a whole new legal fight. The billion-dollar question now is, does this new gentler rule apply to all the cases that were already in the pipeline? And right now, the courts are totally split. Some judges are saying, yeah, this was just a clarification of what the law always meant, so it applies to old cases. But other judges are saying, nope, this was a major change to the law, so it only applies going forward. This uncertainty has left hundreds of lawsuits just hanging in limbo.
Now, you might be sitting there thinking, okay, that's a wild story, but it's just an Illinois thing, right? Well, not exactly. The BIPA phenomenon has sent shockwaves across the entire country, and it's inspiring a whole new wave of biometric privacy laws everywhere.
And here's the crucial difference maker. Look at that last column. Enforcement. Sure, states like Texas and Washington have similar laws on the books, but only Illinois gives individuals a private right of action. That's the legal jargon for the power for you, a regular person, to sue a company directly. That is the secret sauce. It's the engine that has fueled thousands of class action lawsuits in Illinois while they're basically non-existent everywhere else. And this trend is definitely growing. We're seeing BIPA-style bills pop up in state legislatures in places like New York and Massachusetts, and cities are jumping in too. New York City passed its own law for retailers, and Portland, Oregon went even further, banning private companies from using facial recognition in public places altogether. It's quickly becoming a very complex, very messy national patchwork of rules.
So, after all that, what are the big takeaways? If you're a business using this kind of tech, the compliance checklist is actually pretty clear, and it mirrors those 5 pillars of BIPA. First, know the laws where you operate. Second, have that public data policy. Third, and I can't say this enough, get written consent before you collect anything. Fourth, protect that data like it's gold. And finally, don't forget your partners. Make sure any third-party vendor who touches this data is also playing by the rules.
And that really brings us to our final question. I mean, think about it. From unlocking your phone to clocking in at work, this technology is weaving itself deeper into our lives every single day. The story of BIPA is this huge flashing warning sign. It raises a critical question for every single one of us. As this tech becomes the new normal, is your organization, and are we as a society, truly ready for the privacy backlash that is sure to follow?